think we'll go ahead and get started. First, I'd like to welcome everyone here to the Commission this morning. We're here to talk today about an often underestimated issue, and that is the importance of pole attachments in our nation's infrastructure. We're discussing the issue today, but it's certainly not a new issue. At the heart of the issue is recognizing that we need a system to manage pole attachment access between communications entities and power entities. Timely and transparent pole attachment was recognized in the National Broadband Plan as a key ingredient to the deployment of broadband facilities. What's fairly unique about pole attachment regulation is that the FCC is responsible for setting policies, but the states that regulate pole attachments directly may opt out of and certify out of federal regulation. Relying upon many of the ideas and policies of several state commissions that regulate pole attachments directly, the FCC issued a further notice of proposed rulemaking in May of this year, enumerating specific proposals to improve access to pole attachments by entities deploying facilities. We have a great opportunity here today to learn from the experiences and the efforts and the work of some of these state commissions as we prepare to implement rule changes of our own. Just to clarify at the beginning, the focus of today's discussion will be on pole attachment access issues. While the rates that attachers pay and the formula used to ascertain these rates are obviously a hot and pressing topic and one that was squarely teed up in the notice of proposed rulemaking, today's discussion will focus on the access and enforcement piece of the process. First, we'll hear from Wes Platt. He's an attorney in the Wireline Competition Bureau, who will provide a summary of the Commission's pole attachment access proposals in that notice. Next, we'll hear from experts from 6 state commissions who will outline the nature of pole attachment regulations that are in place in their areas. Two of these participants will be participating on the phone. Then the FCC and state commission staff will engage in conversation about the issues surrounding the pole attachment policies and hearing from the experiences of the states. And then we'll turn at the end to questions from the audience, both in person and online, to ask questions of the panelists. I'd like to emphasize that our comments today should be taken for what they are, and that is simply an honest inquiry into how to achieve the best possible policy outcome. Our comments should not be mistaken as official statements of the Commission on opinion or policy. To encourage participation from a wide variety of interested parties, we are also webcasting this workshop so it can be watched live or replayed later. This can be found at reboot.fcc.gov/live. During the event, the online public may submit comments and questions by emailing outreach@fcc.gov or via Twitter using hashtag, I'm not a tweeter, so I apologize, FCC Workshop. I also wanted to share that a recording of today's workshop will be included in the rulemaking proceeding, a video of it. And also, as many of you know, and as many of you have probably already submitted comments, we have an open proceeding and the reply comments are due next week, and we look forward to hearing from all of you. We're fortunate today to have a number of very dedicated staff here who've been working on this issue. I'd like to thank Natividad Prasad, Cece Seppings, Ian Dillner, and Jenny Prime for helping coordinate the logistics of today's workshop. I'd also like to thank, of course, Marcus Mayer, Jeremy Miller, and Wes Platt, who are here at the table. And I also want to single out the extraordinary work efforts of John Reel, who's on vacation. Don't feel too badly for John, though. He's on vacation in Italy, as I understand it. But it is indeed his deep knowledge and deep care and concern about pole attachments and his drive to develop a well-functional set of rules that keeps all of us going. Now, we've gathered a wonderful group of experts here today. Kwat mentioned how he noticed that we placed them right in between the federal side, as they're often squeezed a bit. But He said that with humor. First, we have Quat Nugent from Connecticut. We have Kate Bailey on the phone from New Hampshire, Peter McGowan from New York, J.R. Gonzalez from Oregon, Dr. John Harvey on the phone from Utah, and John Bentley from Vermont. First, I think we'll go ahead and hear from Wes Platt, who will give us a summary of the proposals contained in the notice. Thank you, Wes.
Good morning, everyone. Welcome to the Poll Attachment Workshop. Few items adopted by the Commission have relied as heavily on the forward-looking work of states as the recent order and further notice of proposed rulemaking. With Section 224C providing for state regulation of poll attachments, the regulatory landscape in this area is truly unique. More than 20 states, including Connecticut, New Hampshire, New York, Oregon, Utah, and Vermont, have taken this path, and along the way, accumulated significant knowledge and experience. As the Commission develops rules to ensure that the terms and conditions of access are just and reasonable for the rest of the nation, those experiences and insights have proved to be an invaluable resource. The further notice, for instance, draws from the plans of today's panelists in a number of ways. First, the proposed timeline for wired poll attachment requests, while incorporating aspects from the Commission's current rules, is modeled after those in place in Connecticut and New York. In particular, the 45-day deadline for the completion of make-ready work is consistent with the approach taken by both of those states. Likewise, the proposal that utilities make available a schedule of common make-ready charges is similar to New York's requirement that make-ready charges appear in each poll owner's operating agreement and be posted on their website. Further, the Commission has proposed to adopt Utah's rule concerning the payment of make-ready work, which would allow applicants to pay in stages and withhold a portion of payment until the work is complete. And finally, the proposal that attachers may use contractors to perform surveys and make-ready work is also based in part on the approach taken by New York. These are only proposals, though, and the Commission is certainly open to revising its approach as a more complete record is developed in this proceeding. Moreover, there are still a number of areas where the Commission has not sought comment on a specific proposal, and for instance, the further notice also asks whether the Commission should calibrate its timeline to fit both the size of the request and the size of the utility, as is the case in Utah and Vermont, or if it should, like Connecticut, provide shorter time limits for small jobs. Whether we should clarify, like New York, what constitutes a sufficient request to trigger the timeline, or, like New York and Vermont, what types of circumstances will cause the clock to stop. Whether the proposed timeline is appropriate for wireless equipment, and also whether it should, like New York's, apply to ducts, conduits, and rights-of-way. Which rules the Commission should adopt pertaining to the approval and certification of contractors and the direction and supervision of contractors, and whether the Commission should adopt a system of dealing with unauthorized attachments like Oregon's, which specifies separate penalties for attaching without an agreement and attaching without a permit, and includes a provision for attacher notification, an opportunity for attachers to correct violations, and a mechanism for resolving factual disputes. As we're in the process of crafting final rules, we'd like to know more about these issues and about others. Luckily, we have a situation where state regulators have had to tackle a lot of these issues already. They know what works and what doesn't work, and we're happy to have them here today. Thank you.
Thank you, Wes. First, we'll hear from Quat Nugent from Connecticut, who will give us a quick overview of the regulations and policies in place in his state.
I suppose I drew the short straw. Good morning. Good morning, everyone. First of all, thank you, FCC, for inviting me. It is an honor to participate in this poll attachment workshop. Let me start with an overview of the Connecticut utility pole infrastructure. There are approximately 850,000 poles in Connecticut. About 700,000 poles are jointly owned by AT&T Connecticut and the Connecticut Light and Power Company. About 130,000 poles are jointly owned by AT&T and United Illuminating Company. The rest of the pole, about 14,000, are jointly owned by Verizon and Connecticut and Light and Power Company. So essentially, AT&T is the dominant pole administrator for the communication gain in Connecticut. A few years ago, Connecticut initiated a proceeding, 070213, in light of the changing telecommunication market in Connecticut, and that the pole attachment practices require streamlining to promote the facility-based competition. So in 2008, Connecticut issues its pole make-ready decision with a series of modifications. Let me highlight some of the key issues. First of all, it's setting a time frame which did not exist before. Specifically, 45 days deadline for make-ready estimate. Upon receipt of the payment, a 45-day deadline for make-ready work. So that's about 90-day timeline. In the case where utility pole attachment is involved, Connecticut allows additional 35 days. In those cases where the application has no make-ready activities or has 4 or less utility pole attachment, Connecticut expects the time interval will be reduced from 90 days to between 30 to 50 days. Second, allowing the third-party attacher to perform its own facilities bonding. Number 3, requiring existing plant safety violation to be corrected within 14 days. Disallowing temporary attachment. Temporary attachment is not meant for expedited attachment of facilities. It is used for those cases involving emergency. Number 4, requiring each existing attacher to transfer its facilities within 14 days in order to make room for the new attachment. Requiring AT&T and Verizon, the pole administrators, to track their own utilities pole attachment applications, similar to that of the third-party attachers. In addition to the pole make-ready decision, Connecticut established a working group consisting of industry representatives. Connecticut also designated a mediation team, essentially Connecticut PUC staff. They separate from Connecticut PUC staff, and their goal are to encourage discussion and monitor the progress of the working group. Connecticut commends the collaborative and accommodating efforts made by the working group. They were able to resolve many disputed issues. They were able to reach mutual agreements while meeting Connecticut's objective. The most significant developed in the working group was a better communication between the pole administrators and third-party attachers. Pole administrator like AT&T developed an efficient tracking mechanism to each attacher in order for them to be informed of the process. To summarize what we did in Connecticut, essentially a 2-year-old pole make-ready reform, essentially there are 2 things. Connecticut made a decisive and important decision. It reformed the pole attachment practices and set specific guidelines and objectives. And then it left the technical issues to the industry to work them out. At the end of the day, the question becomes, did the pole attachment reform work in Connecticut? The answer is yes, it is working. If we look at the statistics, for example, FiberTech, a facility-based provider in Connecticut, They have deployed over 600 miles of fiber optics in Connecticut since 2008, the year that the department issues the pole make-ready decision. That equates to about 21,000 pole attachments within 2 years, or 10,500 pole attachments per year. Now, for a small state like Connecticut, that is very significant. And that concludes my remarks. I'll be happy to answer any question during the discussion. Thank you.
Quat mentioned that he drew the short straw, and I neglected to provide a bio for Quat, so let me just tell you that he's been an engineer for over 20 years with the Connecticut Department of Public Utility Control, and he's had involvement as the lead staff in many of the telecommunications proceedings in Connecticut, including cost recovery, quality of service standards, utility pole attachments, rights-of-way, and construction of facilities. So I apologize I didn't set that out up front. Next, and we'll take questions at the end of the session, as we said before. If Kate is available on the phone, Kate Bailey will go next. Kate is an electrical engineer and has worked on telecom issues at the New Hampshire Public Utility Commission for more than 20 years. She's currently director of the Telecommunications Division. Kate helped craft Kate helped craft the New Hampshire Public Utility Commission's pole attachment rules and has been involved in all telecom dockets in New Hampshire, including pole attachment disputes, the Fairpoint bankruptcy, alternative regulation from incumbent telephone companies, and a host of issues related to the provision of service by competitive providers. Kate, if you're there, you may go ahead.
Thank you. Thank you for inviting me to participate and allowing me to do so by phone. In New Hampshire, our legislature passed an enabling statute in 2007 allowing the PUC to opt out of the FCC rules. We initially adopted interim rules, but they were inconsistent with the FCC's sign and sue policy, so nobody used them. During the interim rules, we promulgated permanent rules, and that was a very contentious process. It took about 18 months. We had 4 rounds of comments and 3 or 4 legislative hearings. In the end, we came up with some permanent rules that specified time requirements. Specifically, a request for access has to be in writing. A survey for an application not exceeding 200 polls has to be completed and the results communicated in 45 days. So from the time that somebody requests access to a poll, the utility has 45 days to either grant or deny the access in writing. And if they deny access, it must be specific. A couple of other things, attachments must be clearly labeled so that when municipal workers are in the field and there's an emergency situation, they know whose attachments are whose. One of the big issues that we had was when space was available underneath the lowest attachment but not above it, the incumbent typically wants to may want to maintain the lowest space on the pole. So we have a rule that allows them to do that, but if they want to maintain the lowest space on the pole, they have to bear 60% of the cost of moving it, and then the CLEC or the attacher would bear the remaining 40% and move into the place where the incumbent used to be. On make-ready work, the rule says, unless otherwise agreed in the pole attachment agreement, make-ready must be complete 150 days after the required prepayments. And that's for up to 200 poles. The rules don't specify what happens if the request for attachment is for more than 200 poles, but typically the applications for attachments are limited by the pole attachment agreements to 200 poles, so CLECs file multiple pole attachment requests up to 200 poles in each request. If make-ready is 10 poles or less and there are no replacements required, then they have to complete it in 45 days after receipt of the prepayment. We don't have any rules about the payment amount or the terms like those proposed in the FCC rules where they pay partially in the beginning and then halfway through and then the balance at the end. I think that's a good idea. Most poles in New Hampshire are jointly owned by the incumbent telephone company and the electric company, and the majority of the New Hampshire service territory is served by Fairpoint, so most of the pole attachment issues involve Fairpoint. The pole attachers' requests have to go to both the electric company and the phone company for a license, and both the electric company and the phone company participate in the survey, but the make-ready work is performed by whoever maintenance area is designated. And so the state is split up about half and half. Half the time it's dealing with the electric company and half the time it's dealing with the phone company. One issue that I would like to point out that we discovered was that the standard telco pole attachment agreement reserves the pole owner's right to limit requests for pole attachments to no more than 2,000 poles on all applications pending at any one time. Now, no incumbent, the pole owners haven't invoked that, but if we had 10,000 pole attachments going on or requests for 10,000 at one time, they could raise that, and that's in their pole attachment agreement. I don't know what we would do with that, but it is in the agreement. Our rules also allow for boxing and extension arms, which was another contentious issue, but it's limited. They're allowed to use boxing. The pole owner can restrict boxing, but it has to be consistent with its own practice as written in its methods and procedures. On extension arms, they have to allow limited reasonable use of extension arms to clear obstacles or improve alignment, but in both cases, the attacher would need express written authorization of the pole owner, which has to be either granted or denied in 30 days from the written request. We also have a provision in our rules to ensure that the new attacher doesn't bear the cost of existing violations, and I'll read you the rule on that because the first time we ever had to deal with it, it was a problem. The rule says, where a pole or existing attachment is not in compliance with applicable standards and codes and must be brought into compliance before a new attachment can be added, the cost of bringing into compliance shall not be shifted to the entity seeking the new attachment. So the first time that we had this issue come up, we had a utility line going across a river, and the state licenses river crossings. And the party seeking attachment had a fully code-compliant proposal, but there was an existing attachment on the pole that did not meet the code with the distance to the water, and it was not licensed. So there was an existing violation that needed to be cleared up. But the pole was only tall enough to add one compliant attachment. So if we granted the new attacher's request, they could go into the space that was available and would meet code compliance, but the existing attachment would still be out of code. If we allowed the existing attachment to move up and meet compliance, there was no room left on the pole for the company who was asking for the attachment and was legitimate. So it took a long time to figure out how to deal with that because the one solution would be to add new poles, but then it was a more complicated structure that had to go across the river. So in the end, the existing attachment was moved up and the new attacher was allowed to overlash on the existing space. But just when you're crafting the rules about that provision about cost, be really careful about the words. Parties can petition the Commission for dispute resolution, but I think that due process arguments can be used to delay the resolution. So if there's any way to streamline dispute resolution, that would be really great. Anecdotally, we've heard from pole owners, or actually from CLECs trying to attach to poles, that most of the time the pole owners don't meet the required time frames that we've set up. Nobody's asked us yet to resolve a dispute over that, but the rules have only been in place since last December, and I expect that they're gathering data, and I believe that we'll have a proceeding to figure out what to do when, you know, X percent of the time, 50%, 90% of the time, they don't make the 45-day survey time frame or the 150-day make-ready time frame. The idea of the consequences in the FCC's proposal to deal with this by allowing authorized contractors to do the work is a great idea, and I'd be interested to hear from New York how that got passed in their rules, because I suspect in New Hampshire that the union would fight tooth and nail over that provision, because Fairpoint isn't even allowed to hire contractors to help get the work done. If there aren't enough union employees to do it, then the union would expect them to hire new union employees. And since the company doesn't know how much time this will take, it's an issue. Many dark fiber providers are seeking CLEC authorization in New Hampshire to qualify for the CLEC attachment rates. The current FCC rules have rates that apply to CLECs and CATVs, and if you're a wholesale provider in New Hampshire, you don't typically get certified as a CLEC. And so I think that is an issue that you should look at in your rules. The other big issue that we had during our rulemaking process was an issue raised by municipalities. The municipalities in New Hampshire want to license every attachment. So if a CLEC wants to attach, even though the pole owners have licenses to be in the right-of-way, some municipalities argue, and there's a state law that says this, that each attachment has to be licensed by the municipality. So what the municipalities, I think, really wanted was for the public utilities or the pole owners to enforce that law for them. The problem is that not all the municipalities have the governing body to deal with it or are even aware of the law. And so in some towns they want licenses, in some towns they don't want licenses. And we tried really hard to keep our rules from being discriminatory. The other issue that the municipalities wanted our rules to address is they believe that they have a legal right to one free attachment space, and in some cases they think that they should have a space left open for them forever in case they may need to use it. And we struggled with that because of the discriminatory concern that we had, in that if there was only 1 foot of space left and a CLEC asked to attach, but there was no municipality on the space, some municipalities would argue that they should be allowed to reserve that space, and the CLECs believe that that was discriminatory. So our rules tried to very carefully leave that issue open, but it is an issue that was raised in a docket that we had earlier before we had these rulemakings, where in one case there was a CLEC who paid make-ready work, and after the make-ready was completed, a municipality jumped in and took the space. So I don't know if the FCC has any authority over municipal attachments, but it's definitely an issue at the state level. And that's all I have. Thank you very much.
Thank you very much. That was very helpful. Next, we have Peter McGowan, who is General Counsel to the New York State Public Service Commission. He provides service in the area of regulation related to electric, gas, steam, telecommunications, and water utilities. Prior to 2006, he spent 9 years as the managing attorney in the department responsible for legal and policy issues relating to the telecommunications and cable industries, including the development of a new regulatory regime for telecommunications corporations and the landmark commission decisions. Thank you, Peter.
Yes, good morning, and thank you for convening this day. I think the FCC has done a really great job of pulling together fundamental improvements that could be made to enhance the ability of attachers to expeditiously and with less cost attach and build out their systems. Let me try to describe the basic problem the way I see it, and let me also mention that the Public Service Commission in New York Public Service Law does require the Commission to prescribe rates for pole attachments and establish the terms and conditions. So we do this function. We cannot certify, we don't certify up to the FCC. We have established rates for all attachers. We have a range, low end, high end. The low end is required for cable, and the Commission has established prices that are basically for all attachers at the lower end of the range. So let me just try to describe very generally the basic problem back many years ago. The pole owners, I think it's fair to say, don't really view pole attachments as a profit center. So as a result, they don't really get a lot of attention, and they don't really spend a lot of time making pole attachments happen. And I think there's also the problem of conflicts where you've got pole owners who are also telecommunications providers. They have a natural incentive not to want to make this easy. So there's a bias towards not really spending a lot of management resource on this, or for making it more difficult than maybe it should be for competitors to attach. So in 2003, after seeing a lot of disputes arise in as competitive providers were trying to build out their systems, like FiberTech, and recognizing that time to the market is really important. These attachers are trying to make a business happen. They need certainty, expectations, and I think it was basically really useful for the Commission to get in there. 2003 did like a year-long collaboration with other parties trying to work through the problems. Came up in 2004 with a policy statement that was pretty detailed. You've heard a lot of the critical elements in that, the timeline, contractors being made available, and all of that, I think, just established a much clearer set of expectations. Probably didn't dot every I and cross every T, but a lot of expectations were established in terms of broad requirements, and as a result, people are, I think, making it happen. The relationship has greatly improved, and I think attachments are being made. Is the process working in New York? I would say I don't have empirical evidence to share with you as to whether it's working, but we depend a lot on complaints. When people have a problem, they are not shy about bringing it to the Commission, and the Commission is generally not shy about solving it. So over the past, I'd say 5 years, since 2004, we really have not seen a lot of complaints, which suggests to me that the solutions that we came up with did create a better relationship and did work out a lot of the bugs, and has resulted in improved access to poles. So I would say that the policies that we've put forth have been successful in expediting access and reducing the cost thereof. I would also say that I don't think there's a causal relationship here, but we have in New York very significant broadband deployment, with approximately 95% of the residential customers having available access to broadband. But there are a lot of other players in this space, like FiberTech, who are trying to build out to businesses who need these pole attachment systems to work. Let me try to describe one practical difficulty that we encountered, and I think it's not a problem, but I actually don't know to what extent it actually got worked out. But one of the things we did was we established a policy which had all of these new expectations, the timelines, the availability of boxing and bracketing, and some of those things were viewed in New York to be common practices that the pole owner industry was using, and were widespread practices, and therefore it was deemed that they should be available to other attachers unless the utility could establish that they refused, that they did not have this for their own purposes. And I'm not aware of any that don't, but I wouldn't necessarily be aware. We did establish this series of policies. I think it's a fairly detailed statement, but it also has some flexibility in it. Expectations are created. One of the things that we then wanted to do was to require the industry to solidify those practices into their legal relationships, which would be pole attachment agreements. And that was actually a lot more difficult than I thought it was going to be. So we asked for the pole owner industry group to modify their agreements to reflect these policies, and they did so. And I think what happened was the number of issues that were presented mushroomed significantly. So we had a series of things that we felt should be modified, changed, improved, and then I think they filed an agreement which had just a lot of wording changes. The attacher side then asked us to allow them to put in their own form of model standard agreement. So we had these two competing model agreements that were really long and really tedious and really involved. A lot of details. I mean, there are a lot of details in our policy, but I think the number of issues that ended up in these agreements was just mind-boggling. So that was a problem. I think in retrospect, we may have been better off saying, update your pre-existing agreements to reflect only those changes needed to bring about the new policies in the policy statement. So anyway, we were preparing to resolve literally hundreds of issues on this pole attachment agreement, and the industries kind of asked us not to do that. They wanted to work it out themselves. We never did end up resolving all of those hundreds of issues, and it's my understanding, and I hope I'm right, is that's because they have been able to work this out themselves. So, we do count on the utilities to behave in a reasonable manner. We do count on the attachers to figure out ways to solve their own problems. I think that they have been able to solve this problem. If they haven't, I guess I'll hear about it after this program. But that was a practical difficulty that, I don't know. Again, we didn't exactly solve it, so hopefully you won't have that problem. Let me also just make a clarification that the Public Service Commission does oversee polls, but we don't oversee a significant number of polls in New York because of LIPA. And LIPA is the Long Island Power Authority. They have oversight over utility infrastructure in Long Island. So there's a very significant portion of New York where they manage their own polls. I actually don't know that much about how that process is working. So anyway, just a clarification. And there's also a number of conduits in New York City that are controlled by a subsidiary of Verizon, Empire Services, I think, is the entity, and they are actually regulated by New York City. That's not all the boroughs, but it's some of the boroughs. Moving ahead, one thing that I thought was very interesting in the FCC's recitation of the issues was remedies. And I think it is really important that you have an ability to resolve disputes, especially disputes involving denial of access to a pole, very expeditiously. I think we've had a pretty good history of having a flexible process where we will apply our resources to pay attention to this problem, get parties to brief the issues very quickly, and dedicate some department resources to get to the bottom of that issue quickly, because denial of access can be very detrimental to the attacher when they need it and they're being unreasonably refused. So I think we've had pretty good success in doing that. I do find it interesting, though, the notion of having some kind of remedy that will discourage unreasonable denials. And One thought that I have is if an entity is, if an attacher brings a dispute to the commission and the denial of access is not found to have merit, then maybe there would be some kind of a simple protocol where attorney's fees would be paid by the entity that was found to be denying. That would both have the beneficial effect of reducing the cost of entry and also the beneficial effect of reducing the incentives to throw up obstacles that are not appropriate to throw up. The other issue that has bedeviled us a little bit is wireless, and I know the FCC is trying to figure out what to do in wireless. It was a little difficult for us to work out because the engineers, and a lot of the work that I'm describing today is really done by the engineers in our organization, not by me. But a lot of concerns, especially in the electric space, the electric engineers get very concerned when wireless attachments come in and go over the electric space and have antennas that reach up sometimes many feet, and that affects, you know, engineering properties on a line, wind, icing, the weighting of the lines differ. It actually affects the aesthetics of a line in local communities. But there have been some develops in New York that I would just bring to your attention in terms of, we don't have standards that apply to wireless, but we do have Verizon with a standardized agreement for attachment of wireless antennas to their poles, and National Grid, an upstate provider of electric, also has developed many years ago a standardized agreement to allow for antennas to be attached to these poles. So we have tried to facilitate the attachment of wireless facilities to poles as well as towers. And we've had a number of attachments of wireless equipment to towers, which I don't think is the subject of today's proceedings. But it has proved a useful alternative to other tall structures. But it's been difficult to standardize these antennas to the extent that, but it does seem to me that it might be reasonable for the utility who's being asked to do these attachments to at least adhere to the original or the initial steps in terms of doing a survey and getting back to the attacher in a standard time frame, and maybe maybe there are unique problems which they will need to work out afterwards, but they should not be subject to undue uncertainty. Let me also just mention that one of the things I noted in reading our policy last night was that we deal with drops, which was drop wires off of the main distribution, and there are some problems with that. We have a flexible policy of allowing attachers to attach to drops without getting a license, as long as they provide notice to the owner within 10 days of doing that, to facilitate access quickly, but also keep the records straight. The issues on drops are just not as significant in terms of engineering. But they probably could be an issue, I don't know, in more rural communities where you're moving the wire a long way from the main pole. So drops could be an issue that you don't want to look at. I also think that the extension arms, one of the things that we did is we wanted to facilitate extension arms, even if it was not on a permanent basis, but on a temporary basis, to facilitate access quickly and then allow for rearrangements after the fact, or later, to rearrange and make more permanent solutions. So the other thing I wanted to mention was we did have a rather significant issue in New York City when a big telecommunications player, Telergy, was trying to enter the New York City landscape, and we had to work out a lot of issues with Con Edison, who had conduit. So they were using the electric space in New York City, and the only thing I really want to say is, boy, it was very difficult. The issues were probably not going to be germane to a lot of other things, but working in New York City is incredibly difficult, and unfortunately that Telergy experience was difficult. We did have to spend a lot of time trying to work out those policies, but hopefully you won't have any place else like New York City. So thank you very much, and I wish you luck in bringing these things to a conclusion, and we look forward to yet even more improvements in the process of attaching to polls.
Thank you very much, Peter. Next, we'll hear from J.R. Gonzalez, who is the Administrator of Safety, Reliability, and the Security Division at the Oregon Public Utilities Commission. J.R. has spent the last 6 years as the Administrator and has oversight over electric operators, natural gas, and liquefied natural gas operators, as well as telecommunications operators. He also has 16 years of experience as an engineer and manager in the electric utility industry, including work on generation, transmission, line design, and metering infrastructures. JR has also spent significant time deploying wireless networks in Canada, Europe, Latin America, and the United States, as well as operating his own engineering consulting practice. JR?
Thank you, Kathy, and thank you very much for inviting me to be part of the panel and before you in this workshop. What I want to do is to share with you, very high level, some of the things we have done in Oregon. I put together a PowerPoint presentation. I've left some of the quote-unquote lower level details for the questions so that we can interact. I've also noticed from my colleagues, the previous speakers, that a lot of issues that were raised were pertaining to safety, and I'll be addressing this hopefully with clarity on this PowerPoint presentation. Okay, one problem with engineers, never give them electronic control. You never know what to do with them. Okay. There we go. The first slide basically is just saying, hey, here I am at this workshop. I do want to point out that the slide in the center that was taken here in the United States, and you can see that, yeah, you can provide open access to attachers to the pole, but then what happens without any safety provision for it? Okay. Again, it's not going to be very sequentially pure, but I'm just trying to capture the key points that we have for Oregon. In 1999, we had the House Bill 2271, which was a recap of the pole attachment rules for Oregon that were enacted in 1979. Basically, the legislature directed the commission to, one, we wanted to put a task force of stakeholders together. We want you to address rental reduction for those good operators out there. We also want you to find ways to penalize those non-good operators out there. And we want to have a users group whereby they can eventually become counselors to the commission. So the task force was formed. The rules for rate reduction was put in place, the sanctions put in place, and we also formed the OJ way. But I do want to highlight one point that's part of the note here. When staff called a meeting of all of the stakeholders at the commission in an informal workshop, was somewhat interesting to be part of that. It's like me coming here today. I don't know anybody, had never met you before. That's what happened then. All of the participants in that room, probably a handful of the participants knew who their colleagues were on the operator, the attacher or user sides. That is no longer the case today. It's been an uphill battle, but we were able to bring all of the parties together. So what ended up coming out of this whole process is that we came up with some key elements. Obviously, we have the safety statutes, very key, the pole attachment sanction statutes, the enforcement component, that's a piece that I want to address in somewhat level of detail here, and the Oregon Joint Users Association. First, the Oregon Revised Statute 757035, which is, we call it the safety statute in Oregon. I'm not going to read what's over there. I'm just going to tell you that this particular statute adopted the National Electrical Safety Code as law in the state of Oregon. It provided for regulations and also enforcement of the safety laws in the state. The revised statute for pole attachment very specifically states that the owner may impose a licensee a penalty charge for several different pieces. So in having the statutes, thank you, sorry about that. In drafting the safety rules, you have all of the rules that were worked on. The thing that I want to state on this one, when I mentioned the formation of the Oregon Joint Users Association, the parties did not know each other very well, let alone get them to quote-unquote come into agreement on anything. When we embarked into the safety rules, it's like all of a sudden staff of the commission became the common enemy to the rest of the industry, and that was the unification of all of those quote-unquote operators in the state. There are about 100 power and telecom operators in Oregon. And it has paid fruit 100 times over in this whole process, which continues to this date. But the safety rules, we talk about the obligation for design, construct, operate, and maintain the network. That's for power and telecom. It talks about the detailed inspections that the utilities must perform. That's power and telecom. They have to have a detailed inspection of their network on a 10-year rotation cycles. They have to identify all of the violations of the NESC, and they have to correct them within a prioritized scheme. So there's a time prescribed for them to repair those violations. We also have vegetation clearance rules, which the power companies have the obligation to do, so do the telecommunication companies. The fact of the matter here is that when you open the right-of-way for anybody to go on your structure, there is a responsibility that goes along with that. You cannot expect that the power company, or I shouldn't say power company, the owner of that pole is 100% responsible for everything that goes on that structure. It must be shared. The moment that you go in there, you have obligations, you have responsibilities. Now the pole attachment rules. For the pole attachment, I think some of the things that we talked about here, we provide a prescriptive methods for dispute resolutions. We identify the OJ way, and we also identify that dispute resolutions, the first step of the operators is to go through the Dispute Resolution Committee with the Oregon Joint Users Association before they will ask for a hearing before the commission. And that has helped a lot. Provides obviously for the rates, and it calls for duties of structure owner and duties of pole occupants. Again, as I mentioned before, everybody has an obligation to and responsibility to go on that pole. Then the sanctions. Now, I cannot imagine any one regulator anywhere trying to get operators and say, okay, we're going to tell you what kind of sanctions penalties you're going to impose on anybody else. It doesn't go, you don't go very far. I don't know if you'd survive even after that statement. So what we did there, we actually, with the Oregon Joint Users Association and all of the operators, we told them that as staff, we wanted to kind of, on this one, we want to be resource to you. We have certain things we want to see in there. However, we want you, the parties, to get together and agree on what is best for you. You know your system, you know your costs, you know what needs to be done. And that's how the rules for the no contracts came up, no permits, other duties that they have, has a choice of sanctions that the operator can choose to apply. The plans of corrections, there are violations if the pole attacher does not address the violation within a certain period of time. Time frames, everything. Again, resolution of the disputes, factual disputes, the rental reductions, how those are computed, and the rental prices as well. By the way, I have, at the end of this presentation, I have a slide that shows the web link. I'm leaving this with Ian, with staff of the FCC, to make available to you. But the pole attachment sanction rules are here, and the safety rules. I just made copies in case somebody has questions pertaining to some of the details that are in there. Okay, enforcement. You can have the best law in the land. If you don't have enforcement, you have not accomplished anything. The question then becomes, who enforces this? Over here you have several examples. The picture on the left is strictly, don't forget, the tennis shoes is not part of the pole attachment there, but all you have is power and communication there. There are no wireless operators on that particular pole. The other four, you do have wireless operators. I want you to focus on the lower one and the upper right two. Those installations are the so-called broadband installations. By the way, I'm not addressing narrowband installations on poles, not here. And that's the one you're talking about, Peter, that goes above the electrical facilities. when we talk about broadband, let me go to the next slide. This is a simplistic view of a pole structure, distribution pole structure out on the field. You see that we have the so-called electric space. Between the electrical space, that line on the bottom side of electric space is the location of the neutral on that distribution pole. Then you have a safety zone, safety worker zone, and that's because communication workers are not qualified to work on energized systems, and that's OSHA 1910 prescribes that very, very precisely. So you have to provide a separation to prevent anybody getting hurt. And by the way, we have had a few people get hurt in Oregon on that. Then you have the communication space, and obviously below that space is the public safety. It's you and I driving underneath those communication power lines. The broadband devices, now you're talking about putting a microprocessor, transceivers, you have the antenna out there, you also have a power supply, and you have a meter on that pole. Because those antennas will go along this communication space, because you're looking between 17 and 25 foot for these broadband installations, not all of them, most of them will be at that particular height. Now you're forcing competition of the wireless attacher into the quote-unquote communication space. Now what's going to happen here is that before before the 96 Telecom Act, everybody was comfortable with the 40-foot pole, distribution pole. Then Telecom Act came about, opened the right-of-way. The poles all of a sudden went up to 45. In some urban areas went up to 55-foot poles, 50 and 55. Now you put wireless. It's not saying that every single distribution pole will be this height, but every pole where you're going to have a broadband system installed, you're going to have to provide for more space in there, which now means that you're going to have to increase the height of that structure again. So the critical components in Oregon that I think I can say that since our rules and everything that we've been working on has worked considerably well, the parties, because they don't not only know each other, they tend to resolve a lot of issues just amongst themselves before anything goes to the OJUA and then comes to us. But anyways, critical safety rules. If there's a recommendation to the FCC is, in your rules, prescribe some safety component to the rules, so everybody have to quote-unquote abide by them. You're not relying on agreements between pole owner and pole user that they're going to be quote-unquote going by the National Electric Safety Code. And if you're going to do that, now there needs to be, somebody needs to think through the process of how you're going to enforce that. How are you going to make sure that people are following what needs to be done there? We have the pole attachment statutes. Basically, you open the right-of-way. One of the questions pertaining to wireless operators is the access wireless operators. In some states, by us being certified, we basically agreed that a wireless operator is a licensee in the state, therefore allowed to go onto that right-of-way, meaning the power companies cannot say no. But the thing there is with the wireless operators is you could provide access to them. What comes in question now is how do you deal with the rates, terms, and conditions, because the space requirement things are different. I don't care how you cut it, it's going to be different. So what we've done in Oregon is we have the rental rates for the wire lines on the pole in the communication space. For wireless, we allow the operator and the wireless operator, the pole owner and the wireless operator, to work on what is best for that situation. Now, someone may claim from the wireless operator perspective, well, the pole owner may ask, burdensome rates. The thing is, wireless operators, any wireless network, that pole is not the only capable site for you to have that system on. You have alternate sites. And having deployed these networks in many places, I can tell you that some sites, in one location, the company agreed to pay $25,000 per month to have the antennas on that building. So that gives you a flavor for some of the disparity that you may have in some of the systems. But I guess what I'm saying is, I think it's prudent that wireless operators be given access to that structure, to that right-of-way. The rates, terms, and conditions, let the parties agree on it, and I don't know if you want to call it market forces, whatever you have, but I guarantee you that the wireless operator is going to get a much better rate from power companies than they will anyplace else. Enforcement. In Oregon, I have a staff of senior engineers and people that have at least 25 years of utility experience, former linemen, so on and so forth. We audit all of the companies annually. On the average, we cite between 2,000 and 5,000 violations a year, and we're only auditing about 2-3 square miles of their service territory. They're much larger than that, obviously. So we're only trying to take a sample of what is out there, and then we prescribe what they have to do. And that gives us a sense of how that work is going for that operator. They have a program that works. And obviously the OJ way. Finally, the OJ way. By statute and by rules, they were formed to advise the Commission on pole attachment matters. The Dispute Resolution Committee, over the past 12 months, we've had 2 cases before the OJ way. They have a standards committee that addresses what kinds of coding you put on the violations, that addresses when they should be corrected. And we also have standards to identify the structure on the pole. It is surprising when you find something on a pole and you cannot find who owns that pole. Oh, that's not my pole. Oh, that's not my facility. So with everything that we try to do, we still run into these kinds of problems. And also, the OJ way, they do an annual training of the NESC, which it's a significant challenge because you have to go through all of the operators and educate them as to what the NESC is. The more educated they are to the NESC, the better able they will be when they go on that structure to know what it is that they are doing. So when they do the attachment, they're not creating violations for others or for themselves. As I mentioned, here are the web links for the statutes, for the rules of the OJ way website. And someone may argue that, well, does the Commission have the constitutionality or the statutory authority to delegate penalties to operators to assign to the people that go on their structure? We did have that. It went through the Court of Appeals, and the laws in Oregon were upheld. So, yeah, very much so. And of late, I don't want, if you want me to go into the details of this incident 3 weeks before the Halloween in 2008, but I'll be happy to talk to you about that later. Thank you.
Thank you, J.R. Next, we'll hear from Dr. John Harvey, who is on the phone with us from the Public Service Commission of Utah. Dr. Harvey works as an economic public policy advisor and analyst in the areas of telecommunications and energy, say that fast. In particular, he served as a designated staff in 2 major Utah pole attachment dockets. The first docket was a dispute regarding pole attachment rate charges, pole attachment records, and inventory surveys for ownership and attachments. The second docket, which grew out of the first, was a rulemaking proceeding updating how pole attachment rates are calculated and developing standard pole attachment agreements to be available for opt-in by entities desiring to make attachments to utility poles in Utah. Currently, there's yet another round of dockets underway in Utah to redefine these standard agreements. Dr. Harvey?
Thank you. First of all, I would like to thank the FCC for inviting me to this, I guess you'd say, workshop or whatever this morning. It's been very enlightening to me to hear my other states' colleagues describe their process. When I went through those 2 dockets that were mentioned, I got the feeling that pole attachments was not a very fun thing, but after listening to the experiences of my other colleagues, I've decided I didn't have it quite as bad as I thought. Anyway, what I'd like to do today for this program is to talk about 2 things. First of all, some general principles that the Utah Commission has tried to, I guess you'd say, stay centered on as we work through a lot of problems and issues and fights among the various parties. And then second, just a few specifics. But before I get into either of those, I would just let people know that we do have our rules online. I'm sure that just about everybody in the country probably does as well. But if anybody wants to see any specifics on ours, they can just go to the State of Utah's website, the Public Service Commission's website, and that's just psc.utah.gov. and it just drills right down to the rules. You can see the links pretty easy. So first off, our general principles. The first thing is we want to minimize any duplication of facilities. We don't want to have duplicate lines going down a street if it's at all possible to avoid that. And the main reason for that is we want to minimize total overall cost to society. Sort of a public interest objective there. We did actually have I guess you'd say the environment of pole attachment evolved to a point where our rural ILECs were preferring to build their own facilities rather than attach to the local power companies because they felt the rates that they were being asked to pay were just so outrageous that they could literally go and build their own line for less. So that was one of the things that sort of got us into our most recent big round. A second general principle is that we believe it's important to treat all parties attaching facilities to those poles equally, and basically on a per-foot basis. Whatever percentage of that pole you're using up, that's the percentage you're going to pay for. And now, obviously, that's a value judgment, and listening to some of the other states here talk, that's obviously not the approach they've chosen, particularly with respect to wireless. But we know that looking around the country, there's people that differentiate by technology and by all sorts of things. But we wanted it to just be neutral with respect to those types of technologies, the type of company, the type of service. So we just say the charges are based on a foot basis, however much you use up. We don't want to let pole owners discriminate against potential competitors in the case of particularly telecommunications companies or related companies owning poles. And we don't want to allow pole owners to discriminate according to ability to pay. So just because they think somebody has deep pockets, we don't necessarily want to allow them to fish into those pockets. And then the third general principle is we want to maximize the efficient use of the resource. And so basically what we've said in our rules is that whenever a pole is put in, that the copper wire, if there is any copper, there may not be in today's world, but when we wrote these rules there was, that's got to go down as far as it legally can so that we can maximize then the potential attachments above that. So on a going forward basis, since we promulgated our rules in 2004, we've just said that you have to do that. And if you don't, if someone comes back later and tries to attach and they're not able to because that original attacher didn't do it right, then they've got to make that up. The hole that leaves is what happens to older attachments prior to our rule. Because certainly going back prior, particularly the 1996 Telecommunication Act, there was a tendency to put those first attachments a little bit higher, just because there's a tendency for those engineers to say they don't want people bumping into them, and a little bit safety margin's a good thing. So when we deal with older attachments, there get to be a few more issues that way, and I may get into those a little bit later. So those are kind of our three general principles that we try to think of as we resolve disputes and as we try to write our new rules. Now, some specific things that we did that I think are worth mentioning. We required each pole owner to submit a standard contract or an SGAT in the case of our telecom providers, which would be available to any legal attacher. So, and we actually got, what would the word be, an astounding amount of pushback on that from particularly a power company in our state. And but eventually that did get filed. And what that does is it gives an attacher, a potential attacher, some leverage in a negotiation. If they've got something that they want that's not in that standard contract, there's a limit to how much they're willing to pay or concede before they just default back to that standard contract. So it does put a little bit of a check on the behavior of the pole owners and those standard contracts have to be approved by the Commission. And so if we see things in there that we think are egregious, then we'll say, no, you can't do that. And that certainly has happened in the initial round of filings. Now, I do need to throw out I guess, clarification or warning, and that is that we now have Pacificor, the major electric utility that serves our state as well as quite a few other states. They've come back in and said they want to put a different standard contract in place than the one that we'd approved for them a few years back. And so that's an active docket before the Commission. So there may be some questions I get that I'm not going to be able to answer because of ex parte issues, but I will attempt to answer anything that I can, and if I inadvertently answer something I shouldn't, I apologize in advance, and I'll I guess commit to try and make right whatever I can. Okay, so that was our standard contract. Another thing was the cost causation in terms of nitty-gritty stuff. Our role is, and philosophy and approach has been that whoever causes costs should be the person that pays for those costs. And so when a attacher comes in, as has been specified by a lot of the other speakers already, there's a make-ready process that they go through. They're going to get a bid from the pole owner to say, here's what would be required. We do allow the potential attacher to do some of that work. They can specify in their request that they want to know how much of it they can do versus how much has to be done by the pole owner themselves. So there's potentially some negotiation there that's in our rules. But in the end, whatever the costs are, they're going to be borne by that new attacher, unless there was some previous a previous case where someone didn't obey the rules, type thing. As I mentioned, we allow pole attachers to use whatever qualified installers they want. They do have to get approval of the specific contractor, but if they can find someone who's got all the proper licenses, who's willing to do it for less, they are free to use them. Let's see what else on that. Yeah, I think that's about it on the cost causation. Then on the turnaround time for the make-ready process, that bid process, this was mentioned in the FCC's opening remarks. We do have sort of a staged process. If it's a very small application, what we consider up to 20 poles, they just have to have everything done in terms of the response within 45 days, and then once the potential attacher accepts that bid, they have 120 days to get the work done. We then have a middle ground, which is if it's greater than 20 poles, but equal or less than 0.5% of the poles of that pole owner's poles in Utah, or 300 poles, then we have a different set of days. And then we have yet a third section which says if it's 5% of the poles or 3,000 poles. And so we have slightly different rules for each of those different categories. And then if it goes above that 3,000 level, then we just say it's going to have to be negotiated between the parties. But if people aren't negotiating in good faith, they can bring it to the Commission to get it resolved. One of the nitty-gritty issues that have come up now and become a real problem in terms of things that have changed from the past is you now have non-rate of return regulated companies that own poles. And the reason I say that's an important thing to consider is if we think of, say, our major local electric company, Pacificor, they are going to be made whole in the end. They go through rate cases on a regular basis. If the pole attachment rate that gets set is not quite right in their mind, even though it complies with the law, whatever their real costs are, they're going to end up in some accounting bucket, and it's going to end up in a rate case. In the case of, say, Quest, who's our major telephone provider, our major ILEC, they don't have that. If whatever their costs are, they are what they are, but there's no guaranteed rate that they get anything back. They're just out there in the marketplace competing with whomever comes along. So part of the reason why we wanted in those general principles to say that there'll be one rate and that people are treated equally is we wanted the poll attachments themselves, the polls, not to be a profit center but not to be a loss center either. We just wanted it to be purely based on the cost of the polls. And our hope there is that we're not penalizing the Quest of the world, but we're also not granting windfalls to anyone else. What we expect will most likely happen over time is that you will see the poll ownership change a bit more, and probably rate of return companies like the power companies will tend to start owning a few more polls than they otherwise might have in the previous world. And then the last thing for specifics is uniform rates statewide versus specific company rates. Our rules have defaulted to the specific company rates based on their actual costs and records. And so, but again, that's a judgment call, and depending how, I guess you could say, interwoven service territories were and poll ownership was, a particular state or a particular jurisdiction may or may not want to do that. And that's what I've got. Thank you.
Thank you very much, Dr. Harvey. Now we'll hear from John Bentley, who is a staff attorney at the Vermont Public Service Board. He has served there since 1982. He has been involved in cases as staff or as a hearing officer concerning electric rates and facility siting, hydroelectric dam modification, water system permitting and rates, and especially cable television franchising and rates. He drafted rules for the board governing dam safety, electric right-of-way maintenance, cable television, and DigSafe, as well as pole attachments. He is also the board's IT staff and networking system administrator. John?
Thank you, and thank you for inviting me to this workshop. The Public Service Board takes what I think may be a different approach from, at least from the FCC and maybe some of the states. Our pole attachment rule requires each pole owner to file a tariff. These are all tariff things, so each company can have its own rates. And then our Vermont Department of Public Service investigates the tariffs when they're filed and makes sure they more or less comply with our rule. The rates themselves are based on the FCC's rate formula, but each company can plug its own numbers into the parameters and come up with rates. The terms and conditions also are part of the tariff, so we get to look at those before they're imposed on the pole attachers. We decided that was really the only way we could go. We have an electric company with, well, of course we're a very small state, but we have an electric company with 160,000 customers, and we have an electric company with 300 customers. They weren't going to have the same agreements. They weren't going to have the same rates. Actually, the disparity in size caused the pole attachment rule proceeding 9 years ago to be extremely contentious. And I kept describing it as being, wild sword fights up and down the stairs in the hallways. But once we finally got the rule in place, I believe we've had one case based on our rule since in the last 9 years. And that was where a fiber optic installer got an agreement with the electric company but forgot to get one with the phone company. So we dragged them in, and they said they'd be good from then on, and that was that for the case. So not a lot of procedural war stories to tell you about. The rates are nice, but we think that the issues of access were far more important especially to the attaching entities. Getting onto the poles is what's important, and really, sorry, I told you can't hear me. Anyways, getting onto the poles is what's important to the attaching entity, and money is important, but not as important as getting the service deployed when you want to get it deployed. So we as has been noted a couple of times, we did have some sensitivity so that a fairly short amount of time is allowed for a small order for polls, application for polls, and longer times for larger numbers. We didn't go by numbers, though. We went by percentages. We looked at if you're trying to attach to less than 0.5% of the polls is one time period. 0.5% to 3% is another time period. Above that has to be negotiated. Again, some of these companies are very small and don't really have engineering staff available to do a lot of the work. In conjunction with that, we said that each poll owner had to have a list of approved contractors that it would allow to work on their polls. So if an attaching entity wants to come in and put up an set of attachments, and the electric owner says, well, we're way too busy, we can't possibly do that, the new attacher can insist that they hire an approved contractor to do the work. Generally speaking, I think that it is contractors who do the work of putting up the attachments. That's not really the issue. But it's getting the electric companies mostly to hire people who are qualified to work on electricity that we insisted that they have approved contractors. Apparently that's worked, since, as I say, we have not had any cases on the subject. With things like boxing and means of attachment, we don't really, we haven't had call to say that the attachers, the new attachers, can use boxing and other techniques, but we do insist that the poll owners, if the poll owners do that, that they at least will do that as part of Make Ready, that they will use that on their own polls. Unlike, I guess, most people, we don't regulate conduit. When we started off, when I first drafted the new rule, I basically aped the FCC's rule and had conduits in there, and the few people who do own conduit in the state, which is mostly Burlington, fairly quickly convinced me that I didn't know what I was talking about and that somebody was going to get killed down those holes if we insisted on trying to change how things are done down there. So we backed off pretty quickly and said, okay, fine. So our rule only does polls. And I mean, Vermont is basically a rock anyway, so conduit is really expensive to build in most of Vermont, so it's not much of an issue there. Anyway, I think the FCC is very wise to be pushing for improving mechanisms to get access onto the polls. But I guess I don't have a lot of experience from litigation to share with you about how those wars can go. So that's it. Thank you very much.
Very good, thank you. I think what I'd like to do now is to take a quick break for like 10 minutes, and then we can come back. And I know that my FCC colleagues at the table have a few questions for the panelists, and I want to provide ample opportunity for folks out there and online to ask questions as well. But if everyone will come back promptly in 10 minutes, that would be great. That'll be right before 10 after. Thank you. Started again, and let me start by also saying that I think Sharon Gillette, who is the chief of our bureau, the Wireline Competition Bureau here at the Commission, she's endeavoring to get back from another off-site speech in time to say hello and provide some closing remarks, so hopefully she'll be able to arrive before that. With that, I think we'll start asking some questions, and I'm not sure whether Marcus, Wes, or Jeremy, any of you want to start and get the ball rolling with a few questions for the panelists?
Well, I'll go ahead and, I guess, kick things off with a sort of a general question for sort of anyone on the panel. I appreciate and found very informative your descriptions of the sort of the general poll attachment regulations and policies in your states. And I know several of you alluded to some of the challenges that have arisen after you develop these policies and actually moving to implementation. And so I was just curious if there were sort of more examples from any of the other states of, for any of the sort of policies or rules that you've developed, were there any either expected or unexpected challenges that arose in implementation? And then do you have any thoughts about perhaps a different way of doing it that might avoid those or other approaches that we might think about? And I sort of throw it open to anyone who would like to respond.
Well, I can take it for Oregon. Before we worked on the rules, we had the policies since 1977, and the policies were drafted by staff and the operators in the state, and basically the policies address the safety provisions, which is the inspection process, corrections, how the party should address any safety concerns, so on and so forth. When we embarked into, basically it's kind of an informal process, I need to mention that, and everything seems to work perfectly well until you have a dispute. And then whatever policies you have in place, they are not worth the paper they were written on, because now you're going after facts and laws and everything in the state. So that is what basically created and pushed us to go towards the rulemaking process. Initially, we expected that with the rulemaking that we would be faced with a lot of issues afterwards, addressing, resolving, closing the gaps, what have you. What we found so far is the opposite. The parties have been working a lot more closer in resolving these issues before they bring to the Commission. In poll attachment in particular, all of the rules under poll attachment Division 28, with the exception of 4 of them, are quote-unquote to be decided amongst the parties. They don't have to follow the rules precisely as they are written. However, if there is a dispute, that's how we're going to quote-unquote evaluate the contract and everything else. So things have been working well. It's not to say that we don't have issues. We do. I mentioned the OJA. We just, this past year, we had 2 dispute resolutions that came before them. But things, they are working, I guess, adult-like, let's put it that way. So that's somewhat unexpected when we started.
And I guess I had raised this earlier, and I think, you know, one of the keys is how hard is it as a new entrant to come in and establish a relationship? I mean, that's one of the ways I think about the problem. And, you know, that becomes especially difficult if you're going from state to state, and you have to now figure out, well, what do I have to do to enter here? What do I have to do to enter here? And it's interesting that Vermont apparently uses a tariff. New York also uses a tariff for the rental charges, but we do not use a tariff for the terms and conditions. So it must be one hell of a tariff that you guys have for the terms and conditions, because that's where a lot of these details get played out. So I guess, you know, how can we make sure that, and some players who need access are big and they're long-standing and they know how to work the system and they probably have a relationship and you don't need to worry about them. It's the new player who doesn't have a relationship, that needs to form a relationship, that you gotta, I think, worry about and understand whether there is a legal vehicle that's clear enough for them to pull off the shelf and not have to start from, you know, ground zero. And as I said, we started that process, and we don't have a tariff for terms and conditions. We have a contract, and I'm hopeful that the standard contract is workable, but I can't sit here and say that I know that contract in and out. But I'd be curious as to what other folks do in terms of making sure that the legal relationship exists between attacher and owner.
For Connecticut, essentially it's echo to New York and Oregon. Essentially, when you put a group of people in a room and tell them to get along, you have to give them specific objectives, but leave it open, flexible for the industry to work them out. For example, safety violation, when the department set the timeline for 14 days to correct safety violation, that was a challenge. AT&T, for example, saying that, came to the department and said that we cannot give the license to pole attachers because we have to correct safety violation, and rightly so. CLEX, on the other hand, said, that's holding the whole process. So what they did in the what come out from the working group essentially is this. They try to distinguish what really violations are. They try to separate what between safety violation and technical violation. For safety violation, they have no problem correcting them. It's required by code, and they will correct them. The technical violation, for example, are not related to safety. That they can correct them as they go along, as long as they record the problems, and that there will be a corrective time frame for that. So AT&T would give out the license to attachers. So that helps the process. In terms of the dispute, as I said earlier, the department has a mediation team. This team is constantly working with the working group, and it has been very effective. The working group, if they have any questions, they talk to the mediation team. And essentially, the mediation team knows what the department thinks. They know what the department wants. So it's very helpful, in a room where they try to iron out some of the issues. So that has been very effective in Connecticut.
To either of our panelists on the phone, would they like to provide an answer to the question?
Well, this is John Harvey with Utah. I think much of what's been said is right on point. The only thing I might add is that a lot of our process where we had to go through, as was mentioned, the complaint and then a rulemaking to get the standardized contract, it really related to sort of a shift in attitude. We had our major electrical utility, Pacificor, basically come in and say, we want to raise our pole attachment rate of not quite an order of magnitude, but a huge amount. And so they were no longer viewing it as something that was available to attachers. They were really viewing it as a profit center. And so having an understanding or trying to convince them, I guess, of what the Commission's view of those poles were was quite a process. But I think over time that it's got in there. But the main implementation problems we had was just that some of the companies wanted to make a lot more money than we were willing to allow them to make, and that just caused sort of some inherent conflicts over time.
Kate?
I don't have anything new to add, but I'm curious if anybody has come up against the issue of the pole owner, anybody who doesn't have rules in place that say contractors can perform the work if the utility can't get to it in an adequate or reasonable amount of time. If anybody has had any issues with that, or if those that don't have that rule in place, if they've run up against arguments that the utility just doesn't have the staff to get that much work done for other people.
Anyone?
This is John Harvey with Utah again. We currently do have a rule like that in place, but prior to 2004, we did not, and we certainly had the utilities just telling people, oh, you've got to wait until we get around to it. And so that's why we put the rule in place. We also allow them the out just from a purely monetary perspective, whether the utility can do it on time or not. If they have a qualified contractor who can do it for less, then they're allowed to do that as well. But we definitely have problems with it prior to that.
Yeah, in Oregon, our rules basically prescribes that for make-ready work or other types of work, let us assume that you have a multitude of requests that come in. The rule says that you can have either no more than 50 pole attachment requests or has to be less than 1/10 of 1% of the number of poles you have on your system in any 30-day period. If, for whatever reason, the request or for the make-ready work is going to exceed the 45 days, which is the time prescribed for make-ready work for the utilities, and the utility cannot perform that, the rule states that the pole attacher, in agreement with the pole owner, can select a contractor to, quote-unquote, do that work. But both parties have to agree on who's going to do that work.
Sure, go ahead.
In Connecticut, we allowed companies to hire contractors, but two conditions. Number one, they have to be competent. They have to have a telecommunications certified to perform works in the public's right-of-way. But the other is really any company that hire that contractor, they are responsible for the work. So the utility company, for example, or the cable company or the CLEC will be responsible for the work.
I have kind of a follow-up question to that. I know that earlier, Vermont, you had talked about the decision about whether a request to attach is large or small, and you talked about the number of poles or the percentage of the poles. In terms of having the data available to make that determination, how readily available is that data? Where is it kept, and that sort of thing, so that that determination can be made?
Well, that would be the company would know that. We don't really have that information about the companies.
Okay. JR, because I think you had talked a little bit about something similar.
Yeah, I concur that the utilities, they know how many poles they have on their system. And if they don't, they have a big problem.
But the states don't keep that information.
No, we do not.
In Connecticut?
No, in Connecticut, I suppose AT&T Connecticut is very efficient. They will handle the workload, so there's currently there's no problem.
And, sorry, if I could ask a related question to, I know you guys have done, a lot of states on this panel have done a lot of work making sure that there are different buckets for large utilities and small utilities and differentiating by size of job and more or less than 200 poles or certain percentages. How did you guys, were those, in terms of crafting those buckets, was that a result of some of the joint user groups that led up to those, to drawing those hard lines? And have you had good experiences with those differentiations? Or how did they come about?
And if I might interject, I think just for the people in the back room, if you're answering a question, just raise your hand so they know which microphone to turn on. Thank you.
Sure. in Vermont, I guess I'd say that this was sort of in the open hearing room negotiation process where we came up with these percentages. Again, with the small utilities, 5 poles might be 0.5%. It might be 1% of their poles. But that was where we worked this out. We did not use some sort of specialized negotiating groups. It was just me.
Okay. In Oregon, as I mentioned, the rule states that has to be no more than 50 poles in a 30-day period, or has to be less than 1/10 of 1% of the number of poles you have in your system. That basically addresses the smaller utilities that you have.
Based on your experience, would either of you draw the lines in a different place today, or do you think that those equations or those figures still make sense?
Yeah, the number, the 50, there were a lot of discussions around what number would constitute a proper number. The pushback that we got from several of the utilities is that anytime someone wants to go on your pole, it's not only a matter of going out on the field and taking a look at the pole. Yeah, we can put some attachments there. You have to look into the conditions of the pole. You have to do the load calculations. You have to look who is there, what kind of things, any make-ready work. So the amount of work may take a lot longer than you would expect it otherwise. So we felt that having a reasonable number that would allow a company to deploy their system in a reasonable way, but also forced the companies to plan their work a little bit better, knowing that the law in the state says you cannot go over this number.
Anyone else?
Yes, this is John Harvey from Utah. I think we took a slightly different approach than was just mentioned by Oregon in terms of our thresholds. We have much larger thresholds. We allow up to 5% or 3,000, whichever's, well, actually we allow up to any amount, but that's kind of our last break point. But what we do is we increase the time the company has to respond. And so a CLEC or any other entity that comes in to attach, they get to make a choice, say, well, I can do a bunch of small ones, and we do count whatever happens within a month as one. But they can do small ones and get it done a little bit faster, or they can do large ones, take a bit more time, or they can do huge ones and they can just negotiate with the carriers. So we've kind of left some wiggle room there on purpose, but put the quote-unquote penalty or the stick is that it's going to take longer the bigger request they make.
Thank you.
But we've had a good experience with them. I think we've had one complaint where they said the utility wasn't complying, but once it got to our level, they worked it out pretty quick.
Thank you. JR?
I have a follow-up question on your statement. When you mention 3,000 poles, how often can a company come to you and ask for a 3,000 pole attachment? Can they come every day, every week, every month, every year? How often is that?
Well, they don't come to us. They come to the utilities.
No, that's what I meant, not to you, to the utilities.
If they go over 3,000 in a month, then they're going to be into the custom negotiate the timelines. If they stay under 3,000, then they would have a timeline. The construction would not be 180 days. I think the make ready is like 90 days or something at that level, but that could be once a month.
You know, I guess it would be really interesting to understand.
And remember that for Utah, what we have is not a whole lot of population. We have less than 1% of the country's population, but we have huge, relatively large landmass compared to that population. So we have a lot of poles, you know, they're just traveling long spans. So we wanted relatively high numbers so that if somebody wanted to come in and get some things done, they could get them done.
As a practical matter, it would be really interesting to understand what is the typical request. Because I would think if you have a huge request like that, you know, you have a major build-out, you're going to develop a much more deeper relationship with the owners, and you're going to work this thing out. It sounds like a big plan. So maybe more. I wonder what the practical implication of the request and what the typical request would look like. And I think if you have somebody who's trying to deploy a high, you know, advanced service to a customer, it might be customer by customer, and they might have a relatively small request. So I would think that New York doesn't have this, you know, sort of buckets thing, but most relatively reasonably, you know, small requests would be fulfilled standard time. If you have a gigantic request, it just seems to me it's going to fall into a different kind of category.
Going back to
I was going to have a follow-up on that. The rationale of 50, we put 30 days there. Having been a distribution engineer and design systems, if someone came to, I don't care, I'm going to assume the company I used to work for with about 1.2 million customers. Any one company that came with 3,000 pole attachments that required my staff to go out and do that kind of work, you're looking at months, and you're dedicating pretty much your entire engineering staff to do that work. That's not the sole duty of those engineers. There are a lot of other work, construction, everything else going on that needs to be addressed. And there needs to be a recognition for what is reasonable for one operator to ask and the other one to respond within a proper period of time that allows you to properly plan. So, quote unquote, everybody is happy. That's why I mentioned that there was a very, very lengthy debate on what is proper and what is reasonable. And a lot of the companies felt that this met that quote-unquote criteria. So.
I was going to say, going back to contractors for a second, have any of the states that allow contractors to perform make-ready work when a utility isn't able to get to it in a timely manner run into problems with safety, reliability, or sound engineering?
In Connecticut.
The person's back there in that window.
In Connecticut, usually AT&T or the electric company would do the pole make-ready work. The contract that I'm talking about is really to perform the attachment. So no, in Connecticut.
I don't have any particular knowledge in New York, but I would think that, again, contractors are allowed, they're certified, they're qualified. If there's a problem with a contractor, boy, I would think that that would be pretty well known pretty early on, and if it's a repeat problem, it's going to create a problem for, you know, the attacher. And it's not going to be long before the attacher dispenses with that contractor.
Yeah, in Oregon, yes, there have been use of contractors to do the make-ready work. Again, if it's basically time constrained, if the utility cannot perform the work, then they allow the pole attacher to, with them, select a contractor that's qualified to do the work on their facilities, that understand their standards, so on and so forth. So, yeah, we've had that, and so far, I haven't had many issues. The law says that you have anything you do has to be within the NESC, and they know they're going to be scrutinized at that.
Actually, in Vermont, I haven't had issues about it, but our rule, in the first place, provides that each pole owner has to certify contractors. So they've already they've chosen the contractors who would do the work, and that work is done under the pole owner's supervision. They're under their control, not the new attacher.
Thank you.
This is Kate in New Hampshire. Can you hear me?
Yes, just speak up a little louder.
In New Hampshire, the CLECs can use contractors to add their attachment once the make-ready work is finished. But typically, Fairpoint will do the make-ready work and replace the pole if necessary. We did have one contractor electrocution about a year ago, and it was a contractor that's used fairly frequently by CLECs. And I guess they were in the, you know, they went above the neutral safety zone, and it was unfortunate. So, you know, our rules require that everybody be compliant with the National Electrical Safety Code, but that doesn't mean that everybody follows those rules.
Just sort of one, I guess, building on that, I know several of you mentioned that issues of wireless attachments, particularly you know, pole top attachments or wireless attachments outside of the communications space, have come up in your states, and I was just curious, as it relates to those types of attachments, sort of for all the panelists, to what extent have issues of wireless attachments arisen, and then what have some of the specific challenges been in terms of dealing with those, either as a matter of safety or process or otherwise?
We have had the issue of wireless come up. We have, as I mentioned, a couple of standard agreements that have been worked out in GRID's territory, and it was interesting because their affiliate, one of the reasons the agreement came about was because their affiliate was organizing and trying to broker between, I think, the wireless and the pole owner, so they wanted to facilitate that relationship. And I tried to ask this question a couple days ago. My understanding is that although the agreement happened and was established and approved by the Commission and raised some unique legal questions, because we have a State Environmental Quality Review Act, which also had to get thought about, because these things present differently than just your regular wired attachment. So we approved that. But my understanding is there were not a whole lot of requests. There were not a whole lot of antennas that were brought to the table, and I don't know if that was economic or other considerations. And I know Verizon has a similar, I don't know if it's similar. Verizon also has an agreement. I don't know whether there has been a lot of activity. But you know, I'm not an engineer, and I don't really understand the engineering very well. But I wonder if the future of you know, broadband and bringing 4G to places is going to create an additional impetus for us to want to solve the wireless problem and make these things a little bit more possible to happen. But we did get requests by T-Mobile wireless industry to establish standards. We struggled with it, and we really had a hard time because it just wasn't clear to us that there were sufficient, that these were sufficiently standardized. And we preferred to see the disputes or see the negotiations work out and see problems that were not able to be resolved. Now, I don't know if that's ideal because that may burden, you know, the wireless companies with having to, you know, do a lot of this work, but it's been challenging to say, yes, we understand now there's a standard wireless piece of equipment, and they do raise problems because they often, as I understand it, go through the electric space, which is very high safety risk problem, and they do present very differently, and sometimes there are powering problems which are just not standard. So we haven't solved that problem.
Connecticut recently issued a draft decision on the wireless attachment. Now the decision will be voted on tomorrow by a panel of commissioners, but I can tell you what's in the draft. Essentially, initially the DAS people, distributed antenna system, came to the department and said, give us the authority to install the equipment over the primary wire, the pole-topped. Later on, cellular phones like T-Mobile and AT&T Mobility jumped on the wagon and participate in the proceeding. The draft decision said that they cannot install wireless equipment above the primary wire. The decision said that the feasibility of the pole-top antenna attachment installed above primary wire is inconclusive because there's no party presented any specific Connecticut construction proposal in Connecticut. Third, it was impossible for the department to evaluate the merits of any construction. However, the department allowed them to install facility over the secondary wires. So it's still pole-top, but it's only above the secondary. Now we're talking about secondary and primary wire. We're talking about 38,000 volts versus 220 volts. So the decision essentially said that there are other alternatives for wireless providers to facilitate their construction. One other thing in the draft decision was that the department said that the pole attachment agreement essentially going to be transparent to the wireline agreements. We understand that the construction might be different. We're talking about equipment to be installed on a pole versus the typical wires. So the department left the technical issues again to the working group, and the working group is currently working on some of that. After tomorrow, the final decision will come out, and there will be specific guidelines for them.
In Oregon, I want to address the wireless component into two different buckets, if you will. The first one is the narrow band, which most likely will go above the primary service line. The fact is that those types of wireless installations have been over transmission towers, lattice towers, poles, what have you, for many, many years. For Oregon, what we look at, everything you're doing is it complying with the NESC, and if you have a wireless system being put in place, Does it have the proper safety provisions that meet the FCC wireless, the frequency exposure to those devices, and also the workability of that system, outages of the transmission line, or not allowing a communication worker to go above the primary line, have to be alignment to do the work, so on and so forth. There are no prescribed, quote-unquote, statutes, rules in Oregon that says that you have to go by all this, except that NESC, you're going to abide by that. Also, those attachments, for now, we basically are, the Commission is allowing the parties to agree on what is best and what makes the most sense. The thing that they got during the pole attachment rulemaking process is the acknowledgement by law that they are licensees in the state. So they have an open access to that right-of-way, not transmission lines, though, for distribution poles, so on and so forth. And the other ones remain as they are. Broadband. Broadband still falls under the wireless, not that there are any quote-unquote rules in place. The space they're going to go on the pole is going to be under the primary line. Voltage is going to be in the communication space, not in all cases, but for the most of the applications will be there. So it does impact the pole attachment, the communication space, size of poles, strength of poles, so on and so forth. Again, they are licensees. To date, we have made we have acknowledged that the parties agree, and the Commission is in agreement to this at this point, that the parties will agree on what is the best rate terms and conditions for them to do that attachment. They have to abide by the quote-unquote NESC. Having said all that, over the past 3 months, I've been in discussions with the Oregon Joint Users Association, with their board, and also with the Northwest Wireless Association on the issue of should we embark into a rulemaking to address wireless attachments on poles in Oregon. And both parties have come back. I did not meet with them together, I met with them separate, that they are very happy with the arrangements they currently have in place. And I posed a challenge to them, which is, if you're happy with what you have in place, why don't you work on a rulemaking that prescribes precisely what you're happy with, therefore everything becomes law, and anything may not affect how this thing moves forward. So for today, wireless operators, regardless of where they fall, they are licensees, and any attachment is between the parties, and we're going to look for the safety provisions of it. Everything they've done, does it meet the NESC?
I had another question. In terms of the time frames associated with the make ready and then actually conducting the work, do you have very many requests to stop the clock in terms of actual activity, and if so, how do you handle that?
The Department, the Connecticut and the utility company understand that there are some circumstances where there's force majeure. The clock is stopped. Emergency restoration are important. So to the extent that if the utility company experience any circumstances beyond their control, what they have to do is they just notify the attachers and tell them, hey, listen, we're experiencing emergency problem. You're not going to get the pole attachment as you wish. And the attachers fully understand.
Thank you. Anyone else? JR?
What I can offer in the make-ready type work, if for whatever reason there will be any circumstance by which the make-ready or whatever work is not going to be getting completed within the time frame, the parties can make arrangements for how to agree, move that forward, either by giving extra days and they can agree on what that is, or get someone else to come in and complete the work.
Anyone on the phone?
We haven't had a request yet in New Hampshire, but I suspect that we will because of the ARA funding in the broadband deployment funds. We had an award for a major project that has to be completed in 3 years, and I don't think that the incumbent is staffed to do that kind of work in that short of a period of time. So it's coming. I don't know how we're going to resolve it.
Thank you. Any other questions?
One other thing that I thought I'd mention, issues of sort of dispute resolution is something that's been mentioned several times, and I just wanted to tee up to the panel the question of sort of what do you think has been successful in your states in terms of processes or procedures for handling disputes or organizations, whether it's a working group or particular processes that you might have in the commission for dealing with disputes. What have you seen that's been successful? And then sort of focusing at the other end of it, as you've developed your rules in the first instance, have you sort of thought about dispute resolution and other particular procedural rules, for example, requests being in writing or other things like that, that you feel like have perhaps helped avoid the need for disputes in the first instance?
Disputes under our rule would be filed by whoever is aggrieved, just like our regular, like any other dispute in Vermont. It would follow our procedural rules. We haven't had any. Maybe it's just the threat that they have to come into my courtroom and I face my craziness. I don't know. Maybe it scares them all away, or I'm not sure why. But anyway, our dispute resolution system is certainly clear. It would be a docket just like a rate case or anything else.
We have I would say, flexible process. It's absolutely critical that these things be in writing. But what's unique about these disputes is that they typically they have a lot of anxiety because usually somebody is under a lot of stress because they need to get access. For example, we actually have one pending now. People are alleging that they're under a stimulus kind of requirement. They're trying to, deploy facilities, and there are deadlines under the Stimulus Act, and so if they don't meet those, there's a lot of consequence. So they are very concerned and claim the need for resolution very quickly. I mean, that's not your typical dispute in our normal processes. So these are unique in that way. And when that happens, we normally have a group of folks who will look at it and say, hey, is this real? Is the request for and need for urgent relief a credible request? And if it is, we will typically get the other side to join issue in writing very quickly, and typically we might call them in, sit down, work through the dispute, and either come up with some mediated solution, or if we need to bring it to the commission for resolution. We also require, and I assume it's adhered to, we require that there be, I forget, 1, maybe 2 steps internally, that they've escalated these things within their organizations so that they're thinking about this dispute carefully and not just, willy-nilly having disputes. They've got to think about it before they bring it to us. So there is that, and again, it's a fairly flexible process of trying to come to what is often just a dispute about their legal rights and which remedy is the appropriate remedy to use.
But it sounds then like that none of you have had occasion to actually have the commission write a decision on any of those disputes. They've been resolved. Okay, thank you. JR?
Yeah, the dispute resolution process in Oregon, pre the poll attachment rules that's currently in force, what prescribed the decision, the dispute resolution process was the statute. The statutes in Oregon deems by the way, the poll attachment agreements are not filed with the commission. The statute acknowledges that every agreement is deemed reasonable until one party states otherwise, then it can be brought before the commission for resolution. There was a case where it was very protracted, very costly by all, I guess, imagination possible for poll attachment purposes. And after those proceedings and the commission order that came about from it, when we embarked into the rulemaking process for poll attachment, we addressed a more prescriptive approach to dispute resolution and basically streamlined that process. Prescribed number of days for responses. It's not just filing a complaint. The parties, they have to be very specific on what that complaint is, all in agreement, everything that has agreed on beforehand, and the unresolved issues that are to be addressed, so on and so forth. So the entire goal is to make whatever dispute that would come before the Commission go more expeditiously through the process and not take the year or so that will take the Commission to issue an order from that perspective. Also, the rules recognize that to bring a complaint to the Commission, it's a whole lot more formal than to allow the parties the opportunity to bring their quote-unquote dispute resolution to the Oregon Joint Hearings Association. They do have a dispute resolution committee. The OJ Way is made up of the peers. These are the poll owners and poll attachers. And once the complaint is made, they have 90 days to quote-unquote provide a determination for that dispute. And if they're not able to quote-unquote come up with a dispute within 90 days, then the parties can request a hearing from the Commission. Having said all that, let us say that it goes through the OJ Way process and a opinion of the OJ Way comes out, but one of the parties doesn't quite agree with that or is not very happy with it. There is no restriction of that party as provided by the statute to actually request a hearing from the Commission at that point.
And does that happen?
We have one that I'm working on as we speak.
And that would be the first one?
Yeah.
Okay. Thank you.
I just want to make this point. You know, one of the things that's really critical is that the dispute resolution process have a fairly clear way of getting a resolution in a timely manner. If it's pretty clear that there is a way to get a resolution in a timely manner, you're much better able to get the parties to work it out themselves. I mean, that does often happen. I think we have had to resolve some disputes, but they've got to understand that the dispute will be resolved in a timely manner.
Can you describe a scenario where you don't think there's a way that a decision can be, you know, you said that's kind of key, is that in the whole process that there be a way for them to reach agreement. Where would you think that wouldn't be feasible?
Wouldn't be feasible?
Yeah.
Oh, gosh, I don't know. It could be, as I said earlier, we had some very contentious issues involving Tellergy, where they were trying to enter New York City, and it was several years ago, so my memory is not going to pull all that stuff out. But they were very difficult, and so it was difficult to resolve those issues as timely as the new entrant wanted to. We deployed a lot of resources to try to figure that out. We had to hold hearings, so it was a difficult dispute resolution process, and unfortunately, there is typically no substitute for deploying resources, you know, quickly, and to understand what you have to resolve quickly and what you don't. Because the last thing we want to do is deploy resources that are precious and becoming increasingly precious to a dispute that does not need to be resolved timely. And so complainers really need to convince us that this dispute needs your attention. And if it does, we tend to deploy the resource to try to resolve it.
That helps. Was somebody else going to make a comment?
This is Don Harvey from Utah. I'd just like to sort of say a second to that previous comment. Our whole current rule that we have grew out of just basically a really nasty complaint process that was going on between Pacificor and Comcast, and it basically involved every aspect one could imagine. And it actually went back a good 3 or 4 years. They had a contract in place between predecessor organizations. When it came time to renew that, they couldn't come to a meeting of the minds. It dragged on and on and on. They kept doing things, both of them thinking the other one was doing something else. And then eventually, Pacificor sends a bill that, for all sorts of things that they thought were justified, that sort of started this whole complaint process that ends up with us going through the entire rulemaking process as a sort of growing out of that. So what I would say is, one, you've got to have a a process in place so that kind of stuff doesn't happen. But then, too, you've got to somehow encourage these companies to work together, because a lot of the dispute that we ended up having to solve basically just came about because these people were just being, stubborn, and they were refusing to look at sort of public interest and all these kind of things, and just stubbornly trying to do, something that obviously in the long run wasn't going to work. So I would say have a process in place, which our rules now do, and then also encourage these people to try and actually work together.
Claude, were you going to add something?
Yes, just very quickly. That the industry knows about Connecticut Commission is that if there's a dispute and they want the department to intervene, they have to know that they have to exhaust all options. Use the department as the last resort. The Connecticut Commission always informally give the hint to the industry that you better work it out, because you don't want the commission to make a decision for you. It can be ugly. So in terms of the dispute, as I said earlier, that we do have a mediation team. So if any problem arises, they first go through the mediation team, and then a formal proceeding.
Yeah, another thought is occurring to me, because you guys actually raised in your NOPR an interesting idea, which is, arbitration. What if, I don't know whether there is experience in this field of disputes of being able to rely on an arbitration process to resolve these disputes. But that was a process that was used in the interconnection world. I remember interconnection agreements that had disputes being resolved not by the Public Service Commission, but by an arbitrator. And I think in those instances the arbitration was allowed to be reviewed by the Commission for a certain number of days. One of the things that I'm a little hesitant about is the issue of safety. And I think it would be very difficult to have arbitrators resolving disputes around these issues if they were going to implicate safety. But I think there might be an interesting way of trying to use arbitration to resolve disputes, have that result be available to a commission for a short period of time for review, and if they did not get involved, then the arbitration resolution could take effect. So it is an interesting idea. I haven't thought about it perhaps as much as I should have, but I do think you're on to something there.
I'm just going to sneeze. I'm thinking about sneezing. Other questions?
Well, this is John Harvey. Is just follow up that last comment. The Utah rules do allow arbitration to be included in the poll attachment agreements, but we also allow the parties to, I guess you'd say, appeal to the commission if they really come out of that, upset about it.
This is Kate. I've tried to facilitate a few disputes, and it doesn't work really well because the party who doesn't get what they want wants more process.
Right.
And so if you do arbitration, there always has to be an opportunity for review. But I think Peter raises a really good point, is that if you're going to leave it to somebody to review it, you have to put really tight timelines on it. And it's pretty rare that a commission is going to draft a rule that says, we'll review these and get them done in 30 days. And, usually these are issues that parties can't agree on. So it's really a tough thing, but I think it's probably key to getting poll attachment done more efficiently, is figuring out a way that is an efficient way to resolve disputes.
Thank you. Wes, did you have a question?
What about joint ownership? Does it ever complicate the attachment process? I mean, are attachers ever required to get 2 surveys, or what happens when the potential attacher is one of the owners?
This is Kate. I don't think an attachment issue would be a problem for an owner because they own the poles. One issue that we had in New Hampshire that took a year to resolve was a CLEC who wanted to attach to electric poles that were on a private property right-of-way. And that raised all kinds of legal questions. And the electric company said, we don't have the, we don't own the rights to give you attachment rights. And, you know, we got into, I'm not a lawyer, but easements and gross and appurtenant easements, and it took forever.
Anyone else? Quan?
The joint ownership, that's a very interesting question. In Connecticut, for example, before AT&T would be an agent for CONP, Connecticut Light and Power Company, even though they are jointly owned. But in February, AT&T is no longer an agent for CONP. So now we do have two landlords, if you will. So the attacher has to submit two applications to each utility custodian. But essentially, AT&T would do the pole make ready work for communication gain. The electric company will take care of the electric gain. So to the extent that for a joint-owned pole, they do have to submit two separate applications.
I remember some issues coming up with joint pole ownership, and some of them were just so, I don't know, difficult that I never was able to penetrate them. But because the arrangements are not always that transparent or clear. But I do remember that we had, maybe it was an isolated incident, but it was an incident nevertheless, of a joint ownership where the attacher was required to talk to both joint owners. And I think we were like, you know, what's up with that? And sort of said, you gotta, someone entity needs to be managing the pole. It's just too difficult to have more than one person to attach to. It doesn't seem, you know, sufficiently organized to me. So we did address that and said one of the pole owners has to be designated as the primary go-to owner.
I don't mean to cut off any of the comments, but I do want to provide an opportunity for people in the audience to ask a few questions. It's about a little bit after 12 now, and I know we promised to wrap up around 12:30. If anyone in the audience has questions, feel free just to walk up to the mic. We'll continue to ask questions if you don't, and the folks online, I think we already mentioned how you can ask questions, and feel free to do that.
Kathy, while you're thinking about the question you're going to ask us, I do want to address the joint ownership of poles. For Oregon, honestly, I'm not aware of a joint ownership. Either a telephone company owns the pole or a power company owns the pole. Regardless, even if there were such a thing in the state, what we look at is the safety provisions for that attachment. Because power carries a much larger safety component to it, we would be looking at the power company to literally be, quote unquote, the owner of anything pertaining to safety there. Having said that, the communication companies by law are also responsible for safety. They also have to do the inspections, much like the power companies do. So we would expect both parties, regardless of joint ownership or otherwise, to do the inspections, identify the violations, and then, quote unquote, go and correct them. I don't know how else to put it, except that safety is the key thing. Who owns the pole becomes a secondary matter. It's not, doesn't rise up to the top.
Can I, as a follow-up to that, when you mentioned if there are safety issues and then they need to correct them, how is the determination made that they actually did? Do they just certify that that issue has been resolved, or does somebody actually go out there and check again after the fact? How does that work?
Yeah, we audit them, and they have to report to us that they've corrected the violation.
Okay, thank you.
Yeah.
Now, I know everyone's clamoring for the mic. Don't push and shove. Thank you.
Hello, I'm Joe Snyder. I'm with National Grid in New York. I have a question for Quant. In your opening comments, you made a comment I didn't quite grasp it, and you mentioned about temporary attachments not applicable for expedited attachment. Can you expand on it?
Certainly. In the proceeding, a CLEC came to the department and say, the violation, the non-compliant violation, is one of the problem that holding the whole process. The utility custodian, the pole custodian are saying, we have violation and we have to correct them. We cannot give you a green light until we correct the problem. So again, the CLEC are saying, we can do temporary attachment while we know that they will fix the violation. And the decision essentially said that until they fix the problem, you cannot go on it. But here's a remedy. Safety violation must be corrected within 14 days. Now before that, safety violation was just like a hanging out there. There's no specific time frame to correct them. So Connecticut set a specific time frame that safety is paramount. Safety is very important to the public and to the utility workers. You violating the code, you got to correct them, and you got 14 days to correct them. So that kind of eliminate the problem for temporary attachment altogether.
Yes.
Good morning. I'm Jack Richards with Keller and Heckman. A number of you mentioned the extensive process that you went through before you adopted the rules, and Connecticut had quite a extended review of the proposed rules and a lot of give and take. JR, you mentioned working groups in Oregon that were useful. There have been advisory type committees along the line. To my knowledge, this is the first time the FCC has held a workshop on the subject of pole attachments. Do you plan on doing more along the lines of what the states have done before you implement any rules?
Are you asking me, or
Yes.
do you want to ask? I'm just kidding. I think it's a very good question, and I think much will depend upon what we see by way of the comments that came in and the reply comments that are coming in. But I do think there's overall a desire to get as much information and to capitalize on the experiences that the states have already undertaken and the efforts already underway. And certainly I think over the last year or so there has been a lot of opportunity for dialogue in advance of the Commission actually passing rules that then would be applicable. So I know I didn't really answer the question, but I would think that that opportunity for continued dialogue will be there.
Part of the concern is that during the National Broadband Plan, which is what formed the basis for the recommendation in the further notice, the electric utility industry submitted extensive comments. None of them were considered at all by the Commission in the chapter on pole attachments. And so the concern is that there's got to be some opportunity to have these issues aired in a fair way at the Commission.
Well, certainly, first, I think it's not necessarily fair to say that just because you didn't see the comments or one didn't see the comments in the plan that they weren't considered, because the Commission really does consider everything that comes before us. And in terms of the opportunity for fair opportunity, I think that's why there's always a rulemaking process, so that to the extent you do have comments and concerns, that they are submitted in the record and they absolutely will be considered. But I think we want to truly take a balanced approach to this. We want to hear all sides, and the Commission will ultimately, do its best to balance them in the right manner. Thank you. Do anyone want to follow up to that, my colleagues? No? Okay. Other questions? An easier one, please? No, I'm just kidding.
I work over in wireless, Don Johnson. When you all were talking about wireless, you mentioned, what about the loading issue? Where is that a problem, or does that come up? In other words, with what a wireless licensee has to put up there, and frankly, the pole can't hold it. What kind is that? Does that become a difficult scenario between the pole owner and wireless operator?
JR? Then Peter?
No, I want to let the engineer speak to that.
Thank you. I don't have to make that comment then. Regarding the wireless attachments, it's not any different from any other attachment on a pole. That's why you have to go through the permitting process before you put any attachment on the pole. And you have a certain number of days before the company will respond. And that is to provide the company the ability to actually go out to look at that pole, look what's on the pole, look what's going to go on the pole, and do the proper analysis to find out will that structure be able to withstand those loads, and if not, what do we need to do to remedy that so you can make that attachment. So it's a must. As an engineer, I cannot see anyone going on a pole structure and just putting things on it without taking into account what that pole is going to be exposed through the years, because you have transversal loading conditions on the pole, you have wind, you have all of the attachments, you have ice loading, and a whole bunch of other encumbrances that may hit the pole, such as trees, branches that are going to come on communication lines, on the power lines, and that structure is not going to be strong enough to withstand. Anyways, I could go on and on pertaining to that. It's imperative that whenever a permit is granted for a attachment, that the utility perform the proper analysis calculations to make sure that that installation will be safe.
And I agree with J.R.
Quad?
Yes. In terms of the wireless equipment, in terms of loading, it's not much of a problem. I mean, we're talking about like a shoebox. What's really problem with the wireless equipment is where they're going to put it. And in Connecticut, they want to put it above the primary wire. And as JR talks about the moment, when you have an external factor, equipment can fall down. So loading is not really a problem. It's really where you're going to put it. And the Connecticut recently, the draft decision indicate that it's inconclusive. The department did not rule it out. It just said at this time it cannot make a determination on this until the industry have deployed wireless equipment in other area of the public's right-of-way, and they would learn, they would gain experience from it, and the department will make a determination in the future.
Anyone else? Anyone on the phone? Okay, I think we have another question.
Jeff Sheldon. For the states that are regulating pole attachments, when you write the rules or get involved in disputes, is it a joint function of your telecom and electric staff? Is it just telecom, just electric, and why, whichever it is?
Yeah, I would say that it is primarily a telecommunications function, but it absolutely is in consultation with the electric folks because of the need to ensure, especially on things like wireless, that loading and engineering issues are taken into account. But often disputes are about money and not about engineering. So we would definitely be a team approach. When I remember doing towers, the electric engineers were all over that stuff, looking at the plans, making sure that it was complying with safety. JR has made the point many times today that safety is absolutely critical, and our electric engineers remind me of that every chance they get.
Anyone else? Do any of the yes, JR?
Yeah, regarding disputes, the way the process set up in Oregon, the dispute, the hearing is filed with our hearings division, and staff usually doesn't receive that quote-unquote complaint up front. We may know of well ahead of time, but once it's filed, goes through the quote-unquote the formal process. What usually happens in some of the ones that we've had, I've assigned some of the staff to be interveners in the case, so they can also participate, much like any other company that would like to be on that. And I usually refrain myself from getting directly involved because most likely I'll be advising the LJ or the commissioners on what is, what isn't at that point. And we keep, try to keep we keep those lines fairly drawn pretty tight. But yeah, that's the process we use, and we'll involve just about anybody that has a stake in it. And staff, since I'm responsible for both sides, I'll basically address both sides to be participating on it.
I think with that, I want to, first of all, I think we'll wrap up, and I just wanted to thank our panelists here, both in person and on the phone. Thank you, many of you from traveling a good distance and others a short distance, but we know how tight everyone's schedules are, so we thank you all for participating, and I thank everyone in the audience for attending. I do have a photo that Sharon wanted us to show. Sharon was at the Public Utilities Commission in Massachusetts, and she thought this audience might be one to appreciate this photo.
Oh, the double pole, huh?
So certainly I think we will continue to dialogue on these issues. I know we have learned a lot ourselves. We'll probably have follow-up questions for our panelists and possibly some of you in the audience, but do feel free to comment in the record, which closes next week. The replies are due next week, and we will continue to work on this issue, and thank you all for your time. Thanks.
Thank you.
Thanks, Kate.
You're welcome. Thank you.
You bet.